Welcome back to the Save the Constitution series, produced by Robert Welch University. Welcome back to Save the Constitution. We hope this series is helping you understand and creating a desire to defend the great document given to us by our founding fathers, the Constitution. We've been considering the branches of the government individually because each branch was meant to be separate from the others. We now turn our attention to the third branch of the federal government, the judicial branch. The mainstay of this branch is the United States Supreme Court. The judicial branch of the federal government is described in the third article of the United States Constitution. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may, from time to time, ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. Article 3, Section 1. Alexander Hamilton wrote about the judicial branch in the Federalist Papers. He explained the importance of the judges holding their offices during good behavior. The standard of good behavior for the continuance in office of the judicial magistracy is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is a no less excellent barrier to the encroachments and oppressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. Why not have the Supreme Court alone? Alexander Hamilton argued against having just one court. The power of constituting inferior courts is evidently calculated to obviate the necessity of having recourse to the Supreme Court in every case of federal cognizance, jurisdiction, responsibility. It is intended to enable the federal government to institute or authorize, in each state or district of the United States, a tribunal competent to the determination of matters of national jurisdiction within its limits. In other words, to keep the Supreme Court from being swamped by cases, the Constitution permits the Congress to set up inferior courts to rule on federal issues. Hamilton wrote about the salaries of federal judges in the Federalist Papers. Next to permanency in office, nothing can contribute more to the independence of the judges than a fixed provision for their support. The remark made in relation to the president is equally applicable here. In the general course of human nature, a power over a man's subsistence amounts to a power over his will, and we can never hope to see realized in practice the complete separation of the judicial from the legislative power in any system which leaves the former dependent for pecuniary resources on the occasional grants of the latter. This is an example of the founders curbing the Congress's power of the purse. If Congress were to control the salaries of the judges, it would control them. Why can the salaries of judges be increased? Gouverneur Morris, a delegate to the Constitutional Convention, explained the reasoning. The value of money may not only alter, but the state of society may alter. In this event, the same quantity of wheat, the same value would not be the same compensation. Because they serve for life, they may need an increase in their salaries to meet their needs. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and the treaties made, or which shall be made under their authority. Article 3, Section 2. Why both law and equity? Alexander Hamilton tells us why the federal courts cover equity and not simply the law, what the law says. It has been asked what need of the word equity. There is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than legal jurisdiction, as the distinction is known and established in several of the states. Why is the Supreme Court to rule on cases regarding the Constitution? Hamilton tells us that the reason for this power depends upon this obvious consideration that there ought always to be a constitutional method of giving efficacy to constitutional provisions. In other words, the Constitution sets up rules, and then there must be a method under the Constitution for ensuring these rules are kept. Hamilton's argument deals in particular with the actions of state governments that go against the Constitution. The Supreme Court can overrule such laws. That the Supreme Court is to rule on laws passed under the Constitution is extremely important. Hamilton wrote, "The complete independence of the courts of justice is particularly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Such, for instance, is that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing." This means, because we have a limited constitution, where the Constitution is the supreme law of the land, a method is needed whereby laws or other acts may be declared unconstitutional and therefore not binding. The method the founders gave us is the Supreme Court, with its authority to interpret and apply the law under the Constitution. However, Hamilton warned, the courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. This means that if the justices of the Supreme Court choose to rule according to their personal biases, instead of ruling in accordance with the Constitution, they usurp power over the legislative branch and prevent the enforcement of proper constitutional laws. Thomas Jefferson was concerned about this role of the Supreme Court. He wrote to William Charles Jarvis, an attorney and public official, "You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. But the Constitution, in keeping three departments distinct and independent, restrains the authority of the judges to judiciary organs, as it does the executive and legislative to executive and legislative organs. The Supreme Court is responsible for judgment. That is all. Otherwise, they rule as an oligarchy. If we turn to them for all constitutional questions, we put ourselves in their hands. If they act as the lawmakers, which they are not, they would take over the legislative branch, breaching their constitutional boundaries. Is the Supreme Court superior to Congress because they can rule that laws are unconstitutional? No. Alexander Hamilton explained how the Constitution should guide the court. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. In other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter, rather than the former. They ought to regulate their decisions by the fundamental laws, rather than by those which are not fundamental. But what if the people want laws or mandates or government actions of any kind that are not provided for in the Constitution? Their representatives cannot do what they or the people desire until there has been a change within the Constitution. As Hamilton explained, until the people have, by some solemn and authoritative act, annulled or changed the established form, it is binding upon themselves collectively as well as individually, and no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such an act. The authority of the judicial branch will also extend to all cases of admiralty and maritime jurisdiction. Article 3, Section 2. The reasoning for this provision is that the high seas do not belong to any state, so matters involving them should be decided at the federal level. The judicial branch of the federal government will have authority to judge relative to controversies to which the United States shall be a party. Article 3, Section 2. The logic of this provision is it would be unjust for the federal government to be judged by a state court. The judicial power shall extend to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states. Article 3, Section 2. These provisions, too, are self-explanatory. When there is division among different states or their citizens, it is logical that such cases would be handled by the judicial branch. The judicial branch also covers cases arising between a state or the citizens thereof and foreign states, citizens, or subjects. Article 3, Section 2. Hamilton explained the reason for this provision rests on this plain proposition that the peace of the whole ought not to be left at the disposal of a part. The Union will undoubtedly be answerable to foreign powers for the conduct of its members, and the responsibility for an injury ought ever to be accompanied with the faculty of preventing it. As the denial or perversion of justice by the sentences of courts, as well as in any other manner, is with reason classed among the just causes of war, it will follow that the federal judiciary ought to have cognizance of all causes in which the citizens of other countries are concerned. This is not less essential to the preservation of the public faith than to the security of the public tranquility. The Constitution specifies when the Supreme Court has original jurisdiction, meaning it is the first court to consider an issue, or appellate jurisdiction, meaning it is appealed to. In all cases affecting ambassadors, other public ministers and consuls, and those which a state shall be a party, the Supreme Court shall have original jurisdiction. Article 3, Section 2. Alexander Hamilton explains the reasoning for this. Public ministers of every class are the immediate representatives of their sovereigns. All questions in which they are concerned are so directly connected with the public peace that, as well as for the preservation of this, as out of respect to the sovereignties they represent, it is both expedient and proper that such questions should be submitted in the first instance to the highest judicatory of the nation. Though consuls have not in strictness a diplomatic character, yet as they are the public agents of the nations to which they belong, the same observation is in a great measure applicable to them. In cases in which a state might happen to be a party, it would ill suit its dignity to be turned over to an inferior tribunal. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Article 3, Section 2. The first part of this clause shows where the lower courts will have original jurisdiction. The second part is of extreme importance. In recent years, we have seen rulings by the Supreme Court essentially becoming federal law. But this gives the people, through Congress, the ability to limit the issues this court can rule on. Don Fotheringham, writing for Freedom First Society, explained, "The constitutional power of Congress to check the court is alive today and remains one of the most timely and compelling mechanisms available to the American people. This means there never was any excuse for our nation's moral standards to be mocked and demeaned by activist Supreme Court justices. Lower court cases, which have been settled on moral or religious grounds, find their way to the Supreme Court by the appeal process. Those kinds of cases, either individually or as a group, can be singled out by Congress and excluded from review by the Supreme Court. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Article 3, Section 2. We have now concluded our study of the three main branches of the federal government: legislative, executive, and judicial. After viewing this portion of Save the Constitution, please share it with your friends. Each person educated about the Constitution can make a difference. We hope you and your friends will enjoy Part 5, The Bill of Rights. Please visit robertwelchuniversity.org and freedomfirstsociety.org for more educational material.